legal vision, I would like to talk about banking law in India and how it is important that we have to think. So, the banking system in India is not a current period one. It is almost a very ancestral, even during the period of the Vedic and also and concurrent to the Sanskrit really in the periods, the banking system was prevalent. Because the documents and the loan documents and other system had been in the Sanskrit really in the Sanskrit normal life during the period of Vedic time. So that time also the banking system was in India, not after the coming of the Sanskrit British. Subsequently, the king rules and kings and also during the king terms, the many banking system was theirs in their respective rule. But after the arrival of the British, the banking law was introduced. The Bank of Calcutta, the Bank of Madras, and the Bank of Bombay, where it was also started by the East India Company people. They also formed the really banking law at the time. Before the independence of India, the banking law was formed. So subsequently, after the independence, many banking laws were brought by our governments in India, including Banking Regulation Act and also the State Bank of India Act, and subsequently more banks act also were introduced. The Reserve Bank of India Act 1933 was also introduced. This act is also up to this time standing. So the banking system is facing more difficulties and has caused more, it has also difficult periods in India. Before it was also 1971, the most banks were in private hands. After that, the maximum banks were nationalized. After nationalization of the banks up to this time, the banks are maximum controlled by the government. Despite the control being imposed by the government, many lapses are there to regulate the banking system, to reduce the non-performing assets, and the more also acts have been introduced. To solve the problems, Debt Recovery Tribunal was introduced after 1993 introduction of the new act, and up to this time the banking code is also introduced. Insolvency and bankruptcy code also is there. So banking system one side to regulate its operation and also it is also distribution of the funds. One side the acts are there and how the bank should be there, how its function would be there like that, and distribution of the loan, everything. Another side, recovery of the also the funds distributed through loan, that is also separate law. So the banking system is also consists of the regulation law and controlling law and also money distribution law and the money regulation law, and the head of the is also all the banks, that's the Reserve Bank of India law, and also the recovery is also to recover the finance, there are also separate laws are there. So to regulate it is also in the recovery of the finance distributed through loans, the debt recovery is established. But through debt recovery, the Sanskrit tribunal, the banks also can apply the Sanskrit for the recovery. It is also helpful. So one side of the regulation of the functioning of the banks and headed by the Sanskrit Reserve Bank of India, another side the distribution of the loans and those recoveries, and the recoveries are also exclusively tribunals and exclusively regulation rules are there. So that is a banking system. It was also really once in Vedic period in different style, but now in different style. That's all. So now the banks are in various kind. A nationalized bank, scheduled bank, and also foreign banks, and the most type of the banks and non-banking finance companies. So the lending money system, not only through banks and NPFC, through NPFCs also, the lending money is being done. So recovery system is entirely different. Recovery laws also really is entirely different. So two types of the system in which the banking system is functioning in India. One side functioning, other side recovery of their loans and everything.